This is Jeff. Jeff is a salesman for a Southern California pharmaceutical company. One day, Jeff got into an argument with his boss over something unrelated to the business. Jeff learned to never cross over his boss. The next day, Jeff was terminated. Jeff is one of the top salespersons in the company, so he cannot understand why he would be terminated, aside from the argument with his boss. Jeff doesn't think it's fair that he was terminated because his boss doesn't like him, and wants to know if he has grounds for a wrongful termination claim. The first thing Jeff must understand is that the law does not get involved in personality conflicts. Wrongful termination laws protect unlawful treatment, and not treatment that is simply unfair. The second thing Jeff must understand is that in California, all employment relationships are presumed to be at will, which means either side can end the employment relationship at any time. There is no indication that Jeff engaged in protected activity, which is addressed in other videos. The claim that Jeff may have is for breach of an employment agreement. One way the at-will presumption can be overcome is if there is an agreement between the parties. The most obvious example is if the parties entered into a contract at the beginning of employment, stating that the termination must be for cause. This is called an express contract. If Jeff doesn't have an express contract, his claim is going to be more difficult, but not impossible. The law recognizes implied-in-fact contracts, which means that the actions of the parties created a binding contract. Factors that indicate an implied-in-fact agreement include the personnel policies or practices of the employer, the employee's length of service, actions or communications by the employer, reflected assurances of continued employment, and the practices of the industry. For example, if the company has a policy that states an employee cannot be fired without 2 written warnings, then Jeff may be able to show that the company violated its own policy. Longevity of service alone usually isn't enough to create an implied contract. However, if Jeff has an email from his boss containing assurances of continued employment, the jury could find that the employer intended to waive at-will employment. If there is proof of an express or implied contract, then it may be time for Jeff to lawyer up.